Jub Maarohanye's lawyer, Terrance Baloyi, says his client is still baffled by the charges against him. He has described the charges as malicious and questioned the motive of bringing charges dating as far back as 2006. Maarohanye appeared briefly in the Johannesburg Magistrate's Court and was released on 10,000 rand bail. He faces charges of rape, attempted murder and assault.
The musician handed himself over to the police at the Brixton police station in Johannesburg. This after a warrant of arrest was issued against him. His legal representative says Jub Jub has lost faith in the justice system. This after it emerged the alleged offences are said to have taken place between 2006 and 2010.
He's devastated. It's at the time where he doesn't understand what are these charges all about, why they crop up now. So he's so disappointed with the justice system and how things are being done. It seems like women are given so much power to an extent that they can bring him down any man who is rising up.
Maarohanye's bail conditions include handing over his travel documents to the investigating officer. He is not allowed to leave the country or make contact with the plaintiffs.
We can confirm as the NPA that Mr. Molemo Maarohanye has been charged with 3 counts of rape, 2 counts of attempted murder, as well as 1 count of assault.
The NPA says Maarohanye's previous conviction has no bearing on the pending case. SABC News, Johannesburg.
For more on this matter, we are now joined by legal expert Nthabiseng Dubazana on the intent of parole and the consequences of its violation in the Jub Jub case. And Nthabiseng, thank you so much for joining us here on the late edition. Of course, we have seen that matter taking place again today in the courts, or rather with Jub Jub handing himself over to officials. Nthabiseng, maybe if you can just start here, what is your analysis of the latest development when it comes to the Jub Jub saga?
Well, when we look at the manner in which the bail application was handled, we can see that it was unopposed. Usually when we are dealing with bail applications, the state has what we call an A1 statement and also the statement of the IO, because there would have been certain investigations that would have been had, and therefore there would be reasons from the IO for denying bail or even granting bail and not opposing it. So at this stage, because of how old these matters are, the state really doesn't have a lot of prima facie evidence that they can use in terms of, opposing bail in any manner. And by the time that this warrant of arrest was issued, clearly the previous conviction that he had was already served. In other words, his parole was done and dusted, and because he was convicted of culpable homicide, it has no bearing on this current case, so it just appears a previous conviction. So there's no real reason to oppose bail. So at this stage, I believe the DPP does not have such a huge amount of evidence that they do have a prima facie case against him. That's why bail wasn't opposed. But we'll see how it goes going forward.
And then Nthabiseng, a number of people are asking, why now? Of course, we know that this stems from an interview that Molemo, Jub Jub Maarohanye did, and of course these are the allegations he made in that podcast, according to reports. But many are saying that this dates as far back as 2006. What do you make of it coming to the fore now?
So when we look at how cases such as this are dealt with, there's always DNA evidence, J88, and stuff like that that the state can work off of. I mean, we're dealing with an assault and an attempted murder. In a normal circumstance, it would be that there's a J88 to show the kinds of injuries that the complainant or the victim was dealing with. When it comes to the rape, it would have been a DNA kit and all of those things. But in these circumstances, all 3 rape cases, attempted murder and assault, there is no concrete evidence to that effect. So which means the state is going to rely on the evidence of the complainant, which is the viva voce evidence of what happened. And then they might find witnesses, we don't know, who can confirm or corroborate the incidents when they happen, which is very unlikely. So which means in 90% of the evidence that's going to be led, most likely, is going to be a single witness kind of evidence. And in that case, courts have to apply what we call the cautionary rule. You cannot take the evidence of the single witness as strong and probative over the evidence of the accused. It has to be such extreme and extenuating circumstances for you to accept that evidence of a single witness over that of the accused. So it's going to be quite interesting to see how the state is going to deal with this matter.
It will be very interesting, especially during a time where gender-based violence is something that's taken very seriously in this country. And of course, the president even saying that it is a pandemic on its own.
Yes, very true. So we need to also balance the wheels of justice, so as it were. So we need to ensure that the rights of accused persons are also taken care of without really violating the rights of the complainant. So it's the way criminal law works isn't as how we would hope it would work in terms of, as normal people. So like I said, the cautionary rule works specifically in single witness evidence, which I think this matter is going to be. Otherwise, they're going to rely heavily on circumstantial evidence, and still there's case law to the effect that if the main case is not as strong and it only is made strong by circumstantial evidence, the court has to be very cautious before finding the accused person guilty beyond a reasonable doubt. So the main case has to be so strong before it should be supported rather by the circumstantial evidence, by other things that would help make the case stronger. It shouldn't rely solely on the circumstantial evidence.
And maybe Nthabiseng, maybe if we can just touch on the issue around punitive justice here versus rehabilitation, especially when it comes to the issues of parole and the consequences of this violation, because Jub Jub was facing a matter before the courts when he was released in 2017 on parole. How do you what do you make of that?
The way our justice system is to rehabilitate the accused. So a punitive justice system is solely to punish the person who offended without assisting the victim in dealing with the trauma, so it is, of having suffered from the hands of the accused person. With rehabilitation, the aim of it is to help the accused person to be reformed, to recognize the error of their ways, and to build a bridge, so to speak, between the accused person and the victim. That's why before parole is granted in our law, there's always interviews and sessions between the accused and the victim or the victim's families to see if there's a way to go forward, to see if the accused has indeed rehabilitated, etc., etc. I believe our justice system is in the right track, because a lot of people even get educated while they're in the system to better themselves when they come out. The only unfortunate part is that once you do have a criminal record, in most countries, not just ours, it is quite difficult to get a job or be employed. But the trajectory of what it is that they want in rehabilitation, it is very good, because sometimes for a punitive justice system, once the sentence has been served, the person comes out still angry without having gone through a lot of therapy, and then tends to repeat the same crime and say, anyway, I'm still going to be handed over, I'm still going to go through the same heartache, I might as well.
And how difficult is it, maybe Nthabiseng, if you can just touch on that as well, is it for somebody to prove a matter which has taken place, it says here 2006, when this case does indeed go to court, how difficult will that be for the person who has actually gone to the police station and opened a case in this matter?
Sure, it's going to be like climbing Mount Kilimanjaro, I believe. It's going to be very difficult to prove. Remember, like I said in the beginning, you need DNA to prove that the semen that was found in the body of the victim matches that of the accused or the suspect in this matter. Then we need to deal with whether or not the accused disputes that the act itself of intercourse did happen. And then we go all through all these steps. Rape, in fact, all crimes in our law have different elements. You need to prove each and every element under each crime. And if one of the elements is not proven, you have not executed your duty to try and prove the accused guilty beyond a reasonable doubt. So you have to go through the intention, the act, unlawfulness, all of those things for each and every one of those crimes. And without tangible evidence, it is going to be quite difficult to prove that. Hence, I'm saying they're really going to rely on the oral evidence of the victims, which are the complainants in this matter, and will most likely be single witnesses in these situations.
And one cannot ignore, Nthabiseng, the issue around Jub Jub, being released in 2017, pertaining to that accident as far back as 2012. And of course, just looking into that issue, would this also then affect this new matter?
Well, only towards the end when it comes to sentencing, in terms of aggravating arguments from the state, when they try to, want the court to find him guilty and therefore give a harsher sentence because of his previous offense. However, in mitigation, what would be used is that culpable homicide is a competent verdict of murder, which also the assault and attempted murders that he's facing now are also competent verdicts of the charge of murder. So they're really not related. So using that to try and increase the sentence of the accused would be not such a good idea on behalf of the state. The only thing that would probably work in that instance, trying to increase the sentence, would be because that the parole ended in 2019, and 3-4 years later, when he is found guilty, it will be looking at the number of years that have passed and see if he has reoffended way too quickly for somebody whose case was only sorted out, rather the parole ended in 2019.
What are your expectations of this matter going forward? I know that you've detailed some of the issues looking into a matter of this nature, but in terms of legally, your expectations, how do you anticipate a case like this, to go about?
So at this stage, we are assuming that we hope at least that the investigations are complete, and on the next occurrence or appearance, then the state will be handing over the docket to the accused attorney, and then they're going to peruse the docket. Once they found whatever it is that they can find within the docket, if it's not sufficient, if they, after reading it, feel like there is no prima facie case against the accused, he has no reason to answer to that case, I would most likely believe they will write a letter to the state to withdraw the charges. And if that fails, then we will see a full-blown trial. So at this stage, I think we just need to hear whether or not it's postponed for further investigations. If there's any, if there's none, we're just going to wait to see that when we get to pre-trial conference, what's going to happen.
All right, then, Nthabiseng, thank you so much for your time and giving us your expertise on this matter. That is Nthabiseng Dubazana, legal expert there, talking about one of our top stories for today. Of course, TV personality and hip-hop artist Molemo Jub Jub Maarohanye handing himself over to the Brixton police station, of course, following that warrant of arrest which was issued by the police. But of course, that will be something that we will be looking into. We understand that he is expected back in court later next month.